Welcome to a fresh episode of Legal Wrangle, where we will track major judicial developments that have taken place in the last few weeks in the world of international taxation. For this, we have selected three important cases. The first one discusses the existence of permanent establishment and withholding tax liability of Mastercard Singapore in India. The second one discusses the attribution of profits to permanent establishment when the activities of non-resident is already compensated at ALP. And the third one discusses opening of foreign bank account by an NRI using an Indian identity card when his Indian citizenship stood surrendered. Our first case deals with an electronic payment service provider, namely Mastercard, which is the applicant in the present case. It has a subsidiary in India, namely Mastercard India Services Private Limited, in which it owns 99% of shareholding. The remaining 1% is held by applicant's immediate holding company, that is Mastercard Singapore Holding Private Limited. Let's understand what exactly happened in this case.
In the provision of its services, the applicant provides the customer with the Mastercard interface processor that connects to Mastercard's network and processing centers. An MIP is about the size of standard personal computer and is placed at customers' locations in India. It is through the network and processing centers outside India that MAPPL is able to facilitate the authorization, clearing and settlement of payment transactions. The Indian subsidiary owns and maintains the MIP placed at the customer's locations in India. The applicant approached the authority seeking clarification as to whether it has a PE in India under India-Singapore Tax Treaty. If answer would be yes, then whether there is a requirement of attribution of global profits of the applicant in India. A clarification was also sought as to whether the fees received by applicant from Indian customers would be chargeable to tax in India as royalty or FTS and whether there is any withholding tax liability.
Now let's see what the authority for advance ruling finally decided. The applicant would be deemed to have a PE in India for services of using global network and infrastructure when processing card payment transaction for customers in India. Arm's length remuneration paid to Indian subsidiary for activities performed in India will not absolve the applicant from attribution of global profits in India if FAR analysis of the subsidiary does not reflect the functions risk of the applicant undertaken by the subsidiary. The use of global network and infrastructure when processing card payment transactions for customers in India will constitute royalty, but the same is effectively connected with the PE in India. As for the fees received by the applicants from Indian customers, the same cannot be treated as royalty and hence not taxable under Article 12 of the India-Singapore DTAA. Applicant is obliged to withhold tax at source on amount attributed to the PE in India and the full applicable rate at which the non-resident is subjected to tax in India. Now let's move on to our second case where the applicant, a Saudi Arabian company, has sought a ruling from AAR as to whether, based on the nature of business support or marketing support activities proposed to be undertaken by the Indian affiliate entity, the said affiliate will be a PE of the applicant under India-Saudi Arabia Tax Treaty if the activities of Indian affiliate were duly compensated on ALP basis in accordance with the transfer pricing regulations in India. Let's understand what exactly happened in this case.
The applicant in the present case is world's largest crude oil exporter. Presently, Saudi Aramco was making offshore crude oil sales to Indian refineries from outside India, such that the title of such crude oil passes to customers outside India on a free on-board basis and payment was received by Saudi Aramco in a designated bank account outside India. all crude oil sales are completed by Saudi Aramco from outside India, and it did not have any office in India. In the meanwhile, to expand its operations in India, Saudi Aramco established a subsidiary in India, that is Aramco Visa India Private Limited, whose primary object was to provide procurement support services. The applicant set up a support team in Aramco India, which would closely extend required support to Saudi Aramco's crude oil sales and marketing department for providing the support function. However, with regard to the conclusion of contracts with Indian customers for or on behalf of Saudi Aramco, such activities would only be carried out by Saudi Aramco.
Let's see what the authority for advance ruling finally decided. Provisions of section 245N read with 245S makes it clear that not only a transaction but also a proposed transaction on which ruling has been sought would get covered under section 245R, and hence the application was maintainable before the AAR. Mere rendering of services by a foreign enterprise will not make it liable to tax in the state where the services are rendered unless the foreign enterprise is making personnel available for providing technical assistance. Subsidiary established by Arabian entity in India for purpose of extending support services cannot be construed as PE under Indian Saudi Arabia Tax Treaty if activities of the Saudi Arabian entity gets compensated on arm's length basis in accordance with Indian TEPI regulations. Now let's move to our last case where an NRI has used the address mentioned in his Indian passport even after surrendering Indian citizenship. The SSE in the present case is an NRI and diamond trader. He was conducting business from USA along with his brother-in-law and partner Kalpesh Javeri, another American citizen. For ease of doing business in Europe and the Middle East, they opened a bank account in HSBC, Geneva in the name of the SSE, his sister and brother-in-law. In the assessment proceedings, the SSE was asked to explain the source of credit entries, to which he failed to prove with the substantial evidence that the deposits were not from India. Let's understand what exactly happened in this case. The department formed an opinion that the SSE was an Indian origin and was using his Indian passport to open the HSBC Geneva account even after obtaining the US citizenship. The information obtained in response to notice under section 133 showed demat account in the name of the SSE, which confirmed that the SSE had interest in India. On perusal of SSE's return filed in India, it was found that SSE was a partner of a firm named Navichand Nawalchand Company based out at Mumbai. It was also observed that SSE's diamond business outside India was not independent of that in India, since he had received a sum as business income under section 28 being interest received from the said firm. Thus, the department believed that the SSE's HSBC Geneva account was never disclosed in his returns anywhere, and thus no tax was paid on the said credits. This resulted in additions in the hands of the NRI.
Now let's see what Income Tax Appellate Tribunal had finally decided. A non-resident individual cannot open a foreign bank account by using the address and proof of identity as mentioned in his Indian passport even when he has accepted US nationality by surrendering Indian citizenship. Source of deposit in foreign bank accounts of NRI merits adequate probe before apportioning income in the name of account holders.
With this, we wrap up this episode of Legal Wrangle. Next time, we will bring some interesting cases from the world of excise and customs. Keep watching TIOL Tube for our upcoming education video series, Learning Curve on the subject of TDS and how it affects all of us. Thank you for watching. Have a good day.